Good morning, dear viewers. I'm so happy to be here again for yet a wonderful session. I want to thank you for always following the Women's Voice, a platform initiated by the Women Rights Initiative, an organization that empowers the women and the youth here in Ginger. My name is Annette Nyonyetono, and I'll be moderating today's discussion. Um, I hope that you invite everyone that is not yet on because we are going to be having an exciting and yet a, a wonderful, important learning session today. And with me, I have a guest. She's going to be introducing herself, but today we are going to be speaking about the rights, but particularly we are going to be looking at succession. Uh, I have a colleague, Esther. Please introduce yourself to our viewers so that they can know who you are and connect better as we continue to discuss.
Good morning, everyone. My name is called Maria Esther. I'm the Legal Aid Officer of Women Rights Initiative, and I would like to welcome you all to Women's Voice. Today, I'll be the panelists. You're almost welcome.
Thank you, Esther. As I said, we are going to be discussing succession, and Esther will go right away to our topic. Please, I'm going to, the issues of the legal matters are not easy issues. They have a lot of hard terms. Sometimes people don't think they can interpret the law. Maybe they don't feel they are in better position to really understand what happens in case you want to the law to help you or to guide you. But we are humbled to have you today because we know that you are knowledgeable and you can guide, you can share information for our dear viewers to also understand and learn and also share. So we'll go straight to our topic. I want to understand what succession is first before we go into other issues.
Thank you so much, moderator. So when we talk about succession, succession basically means that when does this right start? When a person dies, what happens next? So when we talk about succession, we mean that upon death of a beloved one, upon death of a friend, upon death of a spouse, what happens then to their estate? What happens then to the property they had? And who benefits from it? Who has the right to benefit from it? Who has the right to access those things? So when we talk about succession and rights, we basically look at what rights do people have upon death of their beloved one, what rights do people have upon death of a spouse. So in simple terms, I would say that is succession. So
Hmm.
maybe to go ahead. Yeah, maybe
Yes,
to go
please.
ahead. When a person dies in Uganda, we succession rights are governed by the Succession Act of Uganda. It is chapter 162 of the Ugandan Act. So in Uganda, when a person dies, two things happen. They either die tested or intestate. So when you go on ahead and when you say someone has died tested or intested, when someone dies tested, this is whereby they have left a will. Uganda recognizes wills that in that when a person passes on and they have a valid will, there are two kinds of wills in Uganda that a person can make. And when you look at that is part 9 of the Succession Act, it provides for these various kinds of wills that a person can make. there is a privileged will. A privileged will, this basically goes, maybe someone is in the armed forces, for example, a soldier, and then in Somalia, they can make a privileged will. And then there is unprivileged will. Unprivileged will, this is the ordinary will that a person can make, that you and me can make because we are stationed here. We are not in armed forces. We are not prone to any shootings or anything. We are not having any warfare. We can make unprivileged will. So maybe moderator, to go on, I could go on to break down how a will can be made, who qualifies to make a will, and when can a will be made, and what makes a will valid, because you can still make a will and it can be challenged and it's invalidated, and then you will be like you did make a will. Okay, thank you. So to go ahead, what validates a will? When you're making a will, first of all, you're supposed to recognize the beneficiaries. Whom do we call beneficiaries? In the Succession Act, we see beneficiaries. These are people who are entitled, for example, your children, your spouse, those are beneficiaries. And then most times people have dependents. Dependents also are supposed to benefit from your estate. Then you also look at when you're making a will, for a will to be valid, it has to be a witness. We call it testation of a will. You're supposed to have over two people witness for you that will, that indeed they were there upon your making and signing of a will. In this age and era, people most times prefer to bring chairpersons to witness the makings of wills and what as they choose to make that process. For someone to also make a will, they're supposed to do it out of free will. You're not supposed to be very sick to the point that your mental state is questionable. You're supposed to be in a very good mental condition. When you're making a will, you're not supposed to be coerced. Maybe your sons are telling you, Daddy, make a will, Daddy, make a will, or Mommy, make a will. It's supposed to come out of you as an individual, you as a person, not someone else coercing you into making a will. And also, for a will to be valid, it's supposed to be dated. You can't just make a will and just leave it blank. There's supposed to be a specific date when the will was executed. There must be people, and then also in a will, maybe some people would choose because maybe you had a fight prior to the day of making your will, you had a fight with your spouse. You don't want to include them in the will. Even if you just recognize them, you can just choose to recognize them and you let them be there because they can challenge the validity of a will. They could say, this will, I'm married to them, and the person didn't recognize me in a will. And then also maybe a question out that I would say is that you nurturing a child with a person does not automatically make you a spouse and doesn't automatically mean that you qualify, you have a right to be in the will. We have four kinds of marriages in Uganda. And if you don't fall in any of the marriages in Uganda, you can't absolutely say that the will a person has made is invalid. However, if a person chooses out of courtesy to recognize you in a will, because in will still, a person can give you a gift, can decide to say maybe I'm giving this land to my moderator because she moderated that day very well. So I'm giving her land and I put it in my will. Yes, that will still doesn't get challenged. However, there are specific people in that if you don't recognize them in a will, your will is like it can be challenged. It's not valid at all. That is the lineal descendants. Those are the children, and then you also look at the spouse, and then dependents, people who are totally dependent on you. So that's what I can say about wills. Moderator.
Thank you so much, Esther. Maybe before you go away from the wills, I wanted to understand because as you're speaking, I was thinking about you were speaking about writing a will. So I was thinking about those people that cannot write, all those people that cannot speak. what happens? Is it not very easy for a person to challenge the will, or even can a will be recorded? Like, can I speak and just recorded? Is that Can that be a valid will?
Yes, a will can you can choose to record your will. It has you said can be verbal or as long as the people who can witness to the fact that this indeed was done in my presence, I was there. But by fine Uganda, we basically believe a lot in the written ones and people sign because it's very hard for electronic evidence is developing, it's evolving in Uganda, and we are still in the age and era whereby we believe in a written will.
So
Yes.
can someone write for you?
Yes, someone can write for you.
Okay, that's
Yes, that's
clear.
why
And also,
nowadays lawyers are the ones who write the wills and people will sign witness. So a person
mhm,
can write for you.
okay, that's clear enough. And also, you didn't speak about. I've had a lot of challenges around the safety, like the storage of the
Mm,
wheels. And in most cases, some people, you might trust someone with a wheel, and then at some point they connive and change, and even wheels disappear. And then people are like, sometimes it's like that guy was so educated. There's no way he would
mm,
have not, written something, and then they look everywhere and it disappears.
mm,
Can you guide about how safe we can probably keep the documents, or what we can do if I don't, especially if I don't trust the people around me? How can I
mm.
keep this document safe?
Okay. Storage. There is no specific provision in law about storages of wills, but I would say you could make as many copies as you can. You could make like 5 copies. You can deposit this will in a bank. They can keep it for you. You can keep this will with your lawyer. You can keep this will with legal personnel. You can equally keep this will with a trusted friend because even if all 5 wills come out and maybe there are 2 that are altered, but the other 3 are saying something else, then there must be a question. So I would advise make as many copies of your will as possible. Have a trusted friend keep for you. Have a lawyer keep for you your will. Have a deposit it in a bank. They can always keep for you. Banks have those storages where they store those things of much treasure. So I would say that could be a good storage and make sure because the way people witness signing of wills is to attest to the fact that a will was made. So maybe upon your demise, maybe no one knows where the will is. Someone will be like, I witnessed him signing this will. So then they will have to look for the will.
Okay,
Mm,
thank you so much, Esther, for guiding, because there are a lot of issues around property grabbing, and
mm,
also people these days die suddenly, and we've had a lot of cases that even up to now still unsolved about property, and
mm,
and wills. And also there's a friend that was sharing with me about
mm,
someone, like when someone dies and then they make a will, and then they leave the properties for their children, but then the children are their children, and so
mm,
there's a lot of issues around the guardians trying to control, trying to take over the property until these children are adults. And in most cases, of course, they abuse the rights. I wanted you to guide. Is it like if I'm a child and my father dies, or my parent dies, is there does the law guide on who automatically takes over, or any immediate relative can come and manage the property until I'm an adult? What really happens? Because I've had a lot of issues around this.
In response to the question, as you're still on, when someone is died with a will, and they leave children of still minors, there is a person who is always appointed in a will who's called an executor. Another thing better that validates a will is that there's supposed to be an executor of a will. So an executor is a person who acts as though he's a legal representative of the part of the deceased. Let me just simple that. The person who dies and appoints an executor in a will, the executor is acting like that person as though he was alive. So if we see that maybe the minors in the when a person has died, this property is vested in the executors to manage that property on behalf of the minors. But however, you being an executor, it doesn't mean that the property has gone back to your names like it's all yours. No, you're just holding this property in trust for these children until they attain the age of majority, or until they become of age. And when they become of age, they have a right to question you, to account for any property that was making part and parcel of their father's estate or their mother's estate. So whether children are minor or not, and then also we have guardians. If property is in the names of children, a person, and you want to deal maybe in that property, maybe you want to sell off some piece of land for purposes of education, there is a part in family law practice where someone applies to become a legal guardian of this child. Even if, let me say, you're a mother to my mother, and my father passed on, but the property is in my name, but I am young, and you feel like you want to sell that property for my benefit, but you're still not at a legal guardian. So you have to go to court, apply to become a legal guardian, and you convince court that whatever you're going to do, it's for a benefit of me. And then court will give you the right to become a legal guardian for me. So even being a parent doesn't automatically qualify you to be a legal guardian of a child. So in case you're dealing with a child's property, you always have to apply to be a guardian. So it's a difference with an executor or an administrator of an estate, in that they are holding this property in trust of this child. And if this child attains that age of majority, they are mature now, they deserve to be given that property, and they have to hold you accountable, and they can actually sue you as an executor of the estate that you failed to manage the estate very well.
Okay. Wow, there's a lot of, and Esther, you'll excuse me, I have a lot of questions about this topic,
It's okay. It's
because
okay.
what what happens to beneficiaries that are not mentioned? Because you said that you have to recognize the beneficiaries in the will, but there are scenarios where beneficiaries are not mentioned in the will, but then they probably the person didn't even know that they had children with someone, and then boom, at the funeral, children begin coming, and they are not in the will, but then they prove that they are children of the deceased. What happens?
So what happens automatically, that will gets invalidated, because as I told you, there are kinds of people that in case they can challenge the authenticity of a will and they can get a will invalidated. So if you have children out there and then like they come at the funeral and there is a will already, that you made a will, but you didn't recognize these children, whether they're adopted children or biological children, let's be clear. Even if they're adopted children or they're biological children or they're matrimonial children or they're children you bought out there, not from your marriage or from your spouse, they are considered children no matter where they come from. So if you make a will and you don't recognize them, you don't include them in the will, automatically that will is going to be revoked, and then it's going to be as though you didn't make a will. So those children have the right to benefit from their parents, for their parents' estate, because you're the parent at the end of the day. At the end of the day, they're not going to get any other parent. So they have a right to benefit from your estate. Even if you recognize your matrimonial children, but you abandon the others, as long as they can prove that lineal descendancy, then automatically your will is invalidated.
Well, so now what happens when someone doesn't make a will, especially those that have a lot of properties? Because for someone who doesn't have anything, they'll bury you, and then it will be the end of story. But what happens when someone doesn't make a will, and then they have a lot of property, and then they have a lot of beneficiaries?
Mhm. Okay. So what happens when someone dies without a will? That's why we call now that person who is dying intestate. This is whereby
Okay.
you just die, you don't have a will, you don't have anything. The law, the Succession Act, provides for administration of estate. And this is totally governed by the Administrator General's Act, Administration of Estate General's Act, Administrator General's Act. It keeps on confusing me because it's kind of long, but it's mostly governed by the Administrator General, whereby this estate of a person is invested in two administrators. This is why there is a difference between tested and tested. For a tested one, there is an executor. Now, when someone dies without a will, they appoint an administrator. So usually, the person who administers an estate, they have also absolute right, like an executor. They act like the representative, the legal representative of the deceased person. So when a person dies without a will, usually you apply for letters of administration. Usually you make a meeting, appoint an administrator, and then you after appointing that administrator, you take these names, the person you've nominated as an administrator of the estate, you take it to the administrator's office, and then when the Administrator General grants you a letters of no objection, then you have make an application to court to have you a court up. It's court that appoints an administrator by the way, not an administrator general. So the best an administrator general will give you is a certificate of no objection. Then you present the certificate to court, and after court shall appoint you as an administrator of an estate. However, also to remind people out there that when you've been appointed an administrator of an estate, it doesn't mean that you now have the right, like the whole property has been reverted to you. You have you think you can deal with the estate no matter how you choose to. No. Every year you're supposed to make an inventory on how you're handling the estate of the children, of the spouse, of whatever you're doing. And then also Section 27 of the Succession Act, it provides for how to divide an estate of a person maybe who has passed on when they didn't have a will. It says that a customary heir is entitled to 1% of that estate. So now we see that the law is providing for how to divide up this estate. And then a wife or a spouse or a husband is supposed to receive 15% of that estate, the total estate. And then dependent relatives, these are people who were dependent to the deceased person. They're entitled to 9%. Then linear descendants, these are the children, specifically adopted or by blood, they are entitled to 75% of that estate.
Wow, this is to me, Esther, I'm learning a lot, because and I know that things change from time to time. But I'm so happy that we are having this kind of discussion for our viewers, for our parents, for our mothers, for our sisters. And as I mentioned, that there has been a lot of issues happening around succession and inheritance. Jackie was asking that if someone had children, if you had children together and you separated, and probably uh, you children were also separated, what happens? But I think that you mentioned earlier that it doesn't matter where the children are, or as long as the beneficiaries and their children, they are entitled to receiving a percentage of the inheritance, or whatever the parent had. But in our country, and I know that It doesn't happen only here in Uganda. A lot of relatives and people that want to come and just grab things make a lot of chaos, and they make they make documents disappear, and a lot of things happen around. But I've also had another issue that is disturbing, Esther, and that is the issue of pension. I don't know if you can share something about if someone is to receive pension, specifically those that work in public offices, and also there are those that die when they haven't really received it, and also those that die when they have started receiving this pension. What happens? Who is it? The same process of going to the administrator general, or there is a different way? Mothers and also people that really need to know this information can take.
So, in response to that issue of pension, first of all, I would like to respond to the part of separation to clarify. In making a will, if you are separated with your wife, maybe not for reason, maybe education or what, but you've been separated for over 3 years, even if you don't include them in a will, it's fine because you've separated, you've been in a process of separation, as well as even if you die without a will, but you had separated from your wife for not purposes maybe of education or anything, but you've been apart with your wife at the time of your death, they have no right to benefit from your estate except otherwise. So now, when you talk about the issue of pension, people dying without processing their pension they haven't got, pension is considered as part of the estate of the or part of the person's estate. So as I told you, the administrator is the one to claim this pension on behalf of others. So you can't handle any pension thing except when you have letters of administration, except when you have been appointed as the administrator of this estate. They will toss you back right, left, and center, but you just need to have the letters of administration and you follow any other protocols that are needed when getting this pension. You can't just come and claim for it out of the blue that you're the wife, you're what. Have letters of administration with you, have letters of probate with you, and they'll successfully process for you pension.
Okay, thank you so much, Esther. And as
Welcome.
we are almost concluding our show, I wanted you to speak about where people that are aggrieved or people that want to seek help can quickly go if they have matters they want to discuss around succession and estate management. Where can we, or where can I seek help?
If you have matters of succession and you need really to seek help, we have the legal aid service providers out there who are determined, dedicated into helping people and giving them legal advice. I would advise you to go to, we have, for example, Human Rights Initiative. You can always seek for independent advice. I would also advise people to talk to a legal personnel about an estate, about how to administer an estate, about even making wills. Of late, Madam Moderator, we see people, the rate at which people are passing on. You just need to have a will because even a will helps you keep track of your property by the way. And even if you made a will, there is something called a codicil. A codicil, this is something else that you make as part of your will. Maybe if you get a house but you had already had a will, you can just make a codicil. It is part of the will, but it's a document that is made maybe on a later stage. Maybe you made a will 2 years ago and this year you've acquired an estate of a house. You can always make a codicil. So I would advise people seek for legal help, talk to professionals. There are these legal aid service providers, they are for free. They can always give you advice. Their work is to give you advice and to guide you in any way. And then also, if you're appointed as an administrator or your board letters on prove that you're an executor, just know this property has not reverted to you, but you're holding it in trust of the beneficiaries of this estate.
Okay. Thank you so much, Esther, and for our viewers. This is the Women's Voice, a platform by Women Rights Initiative, and today we had a legal aid officer talking to us about succession. And of course, this topic is a broad topic, and I know that there are a lot of things that we have not tackled. Esther, maybe we will have you some other time to speak about what happens if someone is not in their mental state to really like take care of manage their property, or if at some point someone is missing and there is a property, we will have time to speak about this. But for our viewers, thank you so much for always following, for always sharing and sparing time to learn. These issues are pertinent because they happen to us. They happen to our relatives, to our friends, to us, and we need to have information to be able to know what to do and to be able to solve these issues. We cannot continue because of the time, but those that have missed, please share with them that this conversation is on our YouTube channel, is on our Facebook page. Please, you can go back if you've missed anything and learn, and also keep sharing. Thank you so much for being with us today. Until next Thursday, God bless you.